Welcome to the deep dive. Today we're tackling something really fundamental. It affects almost every agreement we make, from downloading an app to signing a major lease.
We're talking about what happens when a contract is broken.
Exactly. When things don't quite go according to plan. We're diving into contract law to look at the remedies, the options you have, when there's a breach.
Right. Think about it. You have an agreement, expectations are set. If one side doesn't hold up their end, well, it can cause real problems.
So our mission today,
Our mission for you listening is to get a clear handle on these options, keeping the deal alive, ending it, getting compensated without getting lost in dense legal jargon.
and we're drawing insights from legal learning material to give this a solid structure.
A good foundation, yes.
Okay, so let's start with the ideal situation. Contracts, ideally, they just end, right? Everyone does what they promised. Finished.
Absolutely. That's the natural endpoint, full performance. You pay for your coffee, you get your coffee, contract done. Instantly.
But not all contracts are like buying coffee.
Definitely not. Some are short like that. Others have a fixed term, maybe a 5-year business lease.
And then you have ones that seem to just roll on, like employment or a monthly streaming service.
Exactly, those seemingly indefinite ones. But even with those longer-term agreements, there's usually a built-in way to end them. It's not meant to be a life sentence.
A notice period, maybe, or termination clauses?
Precisely. Mechanisms to bring things to a close are almost always there, based on what the parties intended.
Okay, so let's shift gears. Someone doesn't do what they promised. A breach happens. My first instinct might be, okay, contract over. Is it that simple?
Not usually, no. A breach doesn't automatically kill the contract.
Really?
Not automatically.
Yeah.
This is where being proactive when you make the contract really pays off. Smart parties put clauses in specifically to manage what happens if there's a breach. Think of them as pre-planned responses.
Like contractual fire drills. What sort of clauses?
Well, a very common one is a cancellation clause. The legal term is lex commissoria. It basically spells out, if this specific thing happens, the other party has the right to cancel. Very clear.
What else?
Penalty clauses. These set a specific amount of money to be paid if there's a breach. It makes sorting out damages potentially much easier later on. You agree on the cost of a failure upfront, essentially.
Right, setting the rules for failure. Any others?
Oh, yes. You might see acceleration clauses miss one payment and suddenly the whole remaining debt is due immediately.
Yeah.
Well, can be. Interest clauses state the interest on late payments. And restitution clauses detail what needs to be handed back if the contract is canceled.
So having these clauses gives you a clearer roadmap if things go sideways.
Definitely. Less arguing later, potentially.
But what if you don't have those specific clauses and bam, a breach occurs? What can the innocent party do then?
Okay, now we get to the main menu of remedies, as lawyers sometimes call it. The first set of options is really about trying to keep the contract going to get it back on track.
Right, the goal is still fulfilling the original promise.
Sure.
What's tool number one?
It's a bit of a mouthful, Latin term, exceptio non adimpliti contractus.
Okay.
But the idea is simple. It's basically the I'm not doing my part until you do yours remedy.
Makes sense.
It applies in what we call reciprocal contracts, where my performance is directly in exchange for your performance. Like, I paint your house, then you pay me.
So if the painter hasn't finished the job, I can legally hold back the payment, like a standoff.
Pretty much, yes. Your obligation to pay is tied to their obligation to paint. The exceptio lets you withhold your performance to push them to complete theirs.
So it's defensive if they sue me for payment.
Exactly, it's a defense. But it's also proactive, a tool to compel performance. The key things are the obligations must be truly reciprocal, linked like that, and the other party was supposed to perform first or at the same time as you.
What if they do some of the work, but not all? Say they paint half the house. Can I still refuse all payment?
Good question. If you accept that partial performance, maybe let them leave their ladders there, start using the painted rooms. That can signal you've chosen to keep the contract alive despite the incomplete work.
And that affects my options.
It might limit your ability to just cancel the whole thing later. You'd likely still be able to push for completion, maybe claim damages for the delay or the bits not done. You could probably still use the exceptio as a defense if they then demanded full payment without finishing. It's about what your actions imply.
Okay, so how you react to partial performance matters. What's another way to keep the contract alive?
The other main remedy for keeping things going is specific performance.
And that is.
That's where you go to court and ask the judge to order the breaching party to do exactly what they promised in the contract.
So not just paying money, but actually forcing them to, say, deliver the specific machine they promised or finish building the extension.
Precisely that. In South African law, specific performance is actually considered the primary remedy for breach. The court can order payment, performing an act, or even stopping someone from doing something they promised not to.
And you can ask for this as soon as they fail to perform?
Generally, yes. Once the obligation is due and they haven't met it, you don't necessarily have to wait for a formal default notice in many cases. The courts have discretion, though. They don't grant it automatically in every single case.
Right, the court can refuse. When would that happen?
Several situations. Things like unreasonable restraints of trade courts won't enforce those. Obvious impossibility: if the unique item you were buying was destroyed in a fire, the court can't order its delivery.
Makes sense.
Also, if the breaching party is insolvent, ordering them to perform might unfairly prejudice other creditors, so insolvency is usually a bar.
Are there fuzzier areas where they might refuse? Based on fairness.
Yes, definitely. The court considers overall fairness and practicality. If ordering performance would cause extreme hardship to the breaching party, disproportionate to the benefit for the innocent party, they might refuse.
Like forcing someone to supply water they desperately need elsewhere.
That kind of scenario, yes. Historically, courts were also reluctant to order performance of very personal services, like forcing an employee to keep working a job they hate.
But that's changed a bit.
It has. Courts are more willing to consider it now, even in employment. But it's still subject to their overall judgment about what's just and practical in that specific situation. It's not automatic.
So if the court does order specific performance, how do they make sure it happens? What if the person still refuses?
Well, if it's an order to pay money, it's enforced like any other debt writ of execution, sheriff seizing assets, that sort of thing.
And if it's an order to do something or not do something?
Failure to comply can lead to contempt of court proceedings, which in serious cases could even mean fines or imprisonment. The court might also authorize someone else to perform the act at the breaching party's expense.
Okay, serious consequences. So we've covered ways to try and salvage the contract, but sometimes the breach is just too big, right? The innocent party wants out. Cancellation.
Exactly. Cancellation is the more drastic option. You're ending the agreement early. It's usually reserved for serious, or what lawyers call material, breaches.
And if you planned ahead with that lex commissoria, that cancellation clause.
Then that clause will likely tell you exactly when and how you can cancel. It makes it clearer.
But without that clause.
You can still cancel, but only if the breach is sufficiently serious. If it goes to the root of the contract, really undermines the whole point of the agreement. Deciding if it's serious enough depends entirely on the facts.
So let's say the breach is serious enough. You decide to cancel. How do you actually do it?
Okay. The first crucial step is the innocent party has a choice, an election. Do they affirm the contract, keep it going despite the breach, maybe claim damages later, or do they cancel?
And once you choose?
That choice is generally final. You can't easily flip-flop back unless the other side agrees. If you elect to cancel, you absolutely must communicate that decision clearly and unequivocally to the breaching party.
How? A formal letter.
It needs to be a clear notice of cancellation that actually reaches them. Doesn't usually need specific legal formalities unless the contract says so, but it has to be unambiguous. You can't say, I will cancel next week. It has to be, I am canceling now. A good notice identifies the contract, the breach, the reason for cancellation, states clearly it is canceled, and deals with returning performances restitution.
Could you lose the right to cancel if you wait too long to decide?
Yes, absolutely. If you act in a way that clearly shows you intend to continue with the contract after knowing about the breach, maybe you keep accepting deliveries or keep making payments, that's affirming the contract, you've waived your right to cancel for that breach.
Even if you didn't mean to waive it?
Potentially, yes. If your conduct gives the other party the reasonable impression you're continuing, they might rely on that. Then the principle of estoppel could prevent you from changing your mind later. Delay itself isn't fatal if it's reasonable, but a really long, unexplained delay might be interpreted as tacitly affirming the contract. So acting reasonably promptly is wise.
Okay, so act clearly and relatively quickly. Once cancellation is effective, what's the legal fallout?
The main effect is that the primary ongoing obligations to perform under the contract are extinguished. Done. Finished. If it was an indivisible obligation, the whole thing ends. If divisible, like monthly supplies, only the future unperformed obligations end.
But some parts of the contract might survive.
Yes, things like penalty clauses, clauses limiting liability, exclusion clauses, arbitration clauses, and crucially, the obligation to pay damages for the breach that caused the cancellation, those often survive.
And what about stuff already exchanged? Goods delivered, payments made? You mentioned restitution.
Correct. When you cancel, both parties generally have a duty to return whatever they received under the contract. Restitution. The aim is to put everyone back as much as possible in the position they were in before the contract started.
So you have to offer back what you got when you give the cancellation notice.
That's the general rule, yes. Tender restitution along with cancellation. But there are exceptions. If returning something is impossible because of, say, an inherent defect, or it was destroyed by forces beyond your control, force majeure, the court might relax the rule.
Or if the goods were used up as intended.
Yes, or if they became valueless through normal use, or if only partial return is possible, but the difference can be made up with money. Importantly, this contractual restitution is distinct from a claim for unjust enrichment. It's about unwinding the specific failed contract.
Right, so we've got keeping it alive and ending it. Now the third big category, compensation for loss, damages.
Yes, and this is important. You can generally claim damages whether you choose specific performance or cancellation. Damages are about compensating for the financial harm caused by the breach.
Even if there's a penalty clause.
Even then, the penalty clause might provide a shortcut to quantifying the damages, but the underlying right to be compensated for loss is still there. And remember, courts can reduce excessive penalties.
So what's the fundamental goal of awarding damages in contract law?
The aim is to put the innocent party in the financial position they would have been in if the contract had been performed properly. No breach. We call this their fulfillment position or protecting their expectation interest.
How do courts figure that out?
Often using the difference theory. They compare your actual current financial state with the hypothetical state you'd be in if the contract was fulfilled. This is different from delict or tort law, where damages usually aim to put you back where you were before the wrong happened, covering out-of-pocket losses, the reliance interest. Contract damages can include lost profits you expected to make.
Okay, so to actually get these damages, what does the innocent party need to prove?
4 key things. 1. There was a breach of contract by the defendant. 2. The plaintiff suffered actual financial or patrimonial loss. 3. A factual causal link, the breach caused the loss. And 4. Legal causation, the loss isn't too remote a consequence of the breach.
Let's unpack financial loss. What counts?
It has to be actual, quantifiable financial harm. You can't get nominal damages just to make a point. It must be patrimonial, affecting your financial estate. This can include past losses and also probable future losses, though usually claimed all at once under the once-and-for-all rule.
How was it calculated?
Methods like the difference rule, value promised versus value received, or looking at market values are common. And interestingly, if the breach somehow also resulted in a financial benefit for you, that benefit might be deducted from the damages awarded.
And the causation part. Showing the breach caused the loss.
Yes, the courts use a 2-step approach. First, factual causation, the but-for test. But for the breach, would this loss have happened? If yes, then second, legal causation. Is the link between the breach and the loss close enough in the eyes of the law? Was this type of loss reasonably foreseeable when the contract was made?
What if the innocent party was maybe a bit careless themselves, contributing to the loss somehow? Does their award get reduced?
This is a critical point. The Apportionment of Damages Act, which allows for splitting damages based on fault in delict cases, does not apply to contract breaches. For contract damages, the innocent party generally just needs to show the breach as a cause of the loss. The damages aren't usually reduced based on their own contributory negligence.
That's a huge difference. But wait, surely the innocent party can't just sit back and let the losses mount up.
Absolutely not. That brings us to the mitigation rule. The innocent party has a duty to take reasonable steps to minimize their losses after they become aware of the breach.
They have to try and limit the damage.
Yes. You can't claim for losses you could have reasonably avoided. The law expects you to act like a reasonable person in that situation to stem the bleeding, so to speak.
Okay. And those penalty clauses we mentioned, just to be clear.
Right. They can be a pre-estimate of likely damages, making proof easier, or they can be a penalty proper, meant more as a deterrent. Courts can reduce penalties if they're way out of proportion to the actual harm. And different again are forfeiture clauses, where the breaching party loses the right to get back performance they've already given.
Got it. Before we wrap up remedies, you mentioned one more tool, the interdict. How does that fit in?
An interdict is a court order telling someone to do something or more often to stop doing something. In contract disputes, it can be used almost like specific performance to stop someone violating a negative obligation, like a non-compete clause.
Stopping them from breaching.
Yes, or protecting related rights. It can also be used, crucially, to stop a third party from interfering with your contract. To get an interdict, you generally need to show you have a clear right, that harm is happening or imminent, and that there's no other adequate legal remedy available.
So it's about preventing harm or stopping ongoing wrongs. Okay. One last complex area, the overlap between breach of contract and delict, a civil wrong. When can breaking a contract also be a delict?
Good question. A breach is fundamentally about violating the agreed terms of the contract. But sometimes the action that constitutes the breach might also violate a more general legal duty owed to someone independent of the contract. That's where delict comes in.
Like lying to get someone into a contract.
That's a classic example. Pre-contractual misrepresentation is typically a delict. But if that same false statement was also written into the contract as a guarantee, a warranty, then its falsity could be both a delict and a breach of contract.
So the innocent party might get to choose how they sue, contract or delict.
In some situations, yes. The choice might depend on the type of harm suffered. If the breach caused physical injury, for example, a delictual claim might be more appropriate. Contract damages are usually purely financial. Delictual damages can sometimes cover non-financial harm like pain and suffering, but you have to meet all the requirements for delict conduct, wrongfulness, fault, causation, damage.
And what about claiming purely economic lost profits, say using delict, just because there was a breach?
That's generally difficult. The courts are quite reluctant to allow delictual claims for pure economic loss that arises solely from the breach of a contractual duty, especially with professional services. The idea is that the contract itself should govern the remedies for economic loss stemming from its breach. You generally can't use delict to bypass limitations or terms agreed in the contract for purely economic issues between the contracting parties.
Delict is more for when a third party causes trouble.
Or when the breach causes independent harm, like physical damage, yes.
Okay, wow. We have covered a huge amount of ground today, from, the happy path where contracts just end naturally.
To the messy reality of breaches and the different ways to deal with them. Keeping it alive, canceling it, getting damages.
We looked at the exceptio, specific performance, the whole process of cancellation and restitution.
And then the complexities of damages, causation, mitigation, penalty clauses, plus interdicts, and that tricky overlap with delict.
So to quickly recap the main takeaways, when a contract is breached, you've got options. Broadly, try to enforce it, try to end it, or get compensated for the loss, or sometimes a combination.
Exactly. You might pursue specific performance and claim damages for the delay, or cancel and claim damages for the losses caused by the breach leading up to cancellation.
And which path is best really depends, doesn't it?
Hugely. It depends on the specific breach, what the contract actually says, what losses you've suffered, and frankly, what you want the outcome to be. Do you still need what the contract promised, or is it better to just cut your losses and get compensation?
It really highlights the importance of understanding these possibilities.
It does. So maybe a final thought for everyone listening. Considering this whole menu of remedies we've discussed, how might understanding these options better actually empower you in future agreements you make? Whether that's, a personal contract or a big professional deal.
What parts of a contract might you look at more closely now, before signing?
What seems more critical to perhaps define up front? Definitely something to think about.